We're going to continue with our discussion of damages and remedies for breach of contract. Last week we touched on this notion of reasonable certainty. Remember, of course, that these apply in both direct damages arguments and consequential damages arguments. But a lot of these principles, particularly the one we're going to talk about first today, foreseeability, really comes into play when you have a defendant who's trying to defend against consequential damages claims by the plaintiff. So with respect to reasonable certainty, we saw that courts seem to say we need more reasonable certainty when proving that damages have in fact occurred, and are willing to lighten up a little bit as to showing us the amount of damages, making a claim for the amount of damages that you're entitled to. But we also saw that if the court believes that the damages that you're asking for are too speculative, too uncertain, they don't believe your arguments about essentially what will happen in the future usually, because we're usually debating this in the realm of consequential damages, then you'll have a situation where the court will ratchet down the amount of damages that a plaintiff can seek. And so we saw that in Rancho Pescado. And we also saw that in the Hollywood Productions versus Gabor case, where Jaja was liable, but the court found that Hollywood Productions wasn't really able to prove, at least to the court's mind, the amount of future earnings that they would have lost as a result of Jaja Gabor's breach. So today we're going to talk about foreseeability, and we're going to talk about mitigation. And what I'm going to do is talk about some of the classic cases presented in your textbook, and then for class we're going to look at the modern cases and problems. So our first case is the classic Hadley v. Baxendale, and we're reading the opinion of Baron Alderson. It has to do with the drive shaft on a mill. So this mill would be used to grind grain. It probably would have been water powered, and the water wheel drives the shaft. When that shaft gets broken, the mill can no longer operate. And this is a picture of the actual mill. The mill still exists, at least some of the buildings associated with it do, and as your book points out, they actually held a big conference there about a decade back for the 150th anniversary of this case. So this case is a real classic chestnut for us contracts professors. So we have Mr. Hadley, who's a miller, and Baxendale, Mr. Baxendale, our defendant, who is a carrier, right? Like UPS, like FedEx, somebody whose job it is to transport goods from one place to another. The carrier, and it's not clear why, but due to some neglect, and you see this in the legal reporter note, right, which is the first page of the opinion, is the legal reporter's note. The carrier delayed getting this crankshaft to the repair service, and so Hadley's mill was inoperable for several days, which led him to lose profits. Right? The mill's not operating, he's not making any money. Hadley had paid about $200 in today's money for the shipping, so it wasn't a negligible sum, it was a fairly large sum for the shipping. The plaintiff is claiming damages for the lost profits for the days that the mill wasn't operating, allegedly due to the carrier, Baxendale's, failure to get the shaft to the repair service in a timely manner. And ultimately, Hadley had been awarded about 25 pounds, which would be about $3,000 in today's money. So he got a fairly sizable award from the jury. Right? The judge left the case generally to the jury. The jury, as we have seen juries do so many times, sympathetic, gives them a pretty decent judgment. So now the case is being reviewed. The defendant's claim here is that these lost profits are too remote, right? That they were not something that the carrier would have known about or anticipated. And at the end of the day, the Lord Justice here, Baron Alderson, agrees with the idea that in this case, the damages probably were too remote. But what he does is articulates some standards that suggest that in some situations, it might make sense to give damages if something has happened that the defendant could have anticipated causing the plaintiff damages, causing the plaintiff harms. So he articulates two basic tests here, right? Where two other parties have made a contract which one of them has broken, the damages which the other party ought to receive in respect of such breach of contract should be as may fairly and reasonably be considered either, right, so first test, arising naturally, i.e. according to the usual course of things from such breach of the contract itself, or, second test, such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach of it. So both of these are capturing what is essentially a reasonable foreseeability idea. Either it's just something that would so naturally flow from the breach that the defendant ought to know about it, or it was something that was actually in the contemplation of the parties. And he goes on to explain that especially for this second prong here, if there's special circumstances, then they ideally are actually communicated to the defendant, and the circumstances are such the defendant really should have known about them. And why is it important that these special circumstances be known? Because, and this is quoting, had the special circumstances been known, the parties might have specially provided for the breach of contract by special terms as to the damages in that case. So we'll talk about some of the ways that modern day parties do this, but for instance, you could anticipate something like late fees. If you don't deliver this on time, we get late fees in the amount of X. Now, that might not really capture the business losses that Hadley experienced here, but if Hadley had written in for every day that you're late beyond X day delivering this to the repair shop, you owe me my business losses, and had made that explicit, this would be a really easy case for the courts to solve. The justice here points out, right, that it isn't reasonable under the circumstances to assume that the plaintiff would know that by carrying this particular piece of machinery away from the mill, that work was stopped at the mill. And then he lays out some hypotheticals. Suppose the plaintiffs had another shaft in their possession, put up or putting up at the time, and they were just sending this extra shaft off to repairs. Suppose that at the time of delivery to the carrier, the machinery of the mill had in other respects been defective. And so suppose that it's not even the shaft's fault. It's some other piece of equipment that was also keeping the mill from operating. Here, the special circumstances were, quote, never communicated by the plaintiffs to the defendants. Right? It follows, therefore, that the loss of profits here cannot reasonably be considered such a consequence of the breach of contract as could have been fairly and reasonably contemplated by both parties when they made this contract. For such loss would neither have flowed naturally from the breach of this contract in the great multitude of such cases occurring under ordinary circumstances, nor were there any special circumstances which perhaps would have made it reasonable and natural consequence of such breach of contract communicated to or known by the defendants. I'm going to break that down one more time. He's basically just restating his rule here. But first of all, he says it would not have flowed naturally from this breach of contract in the great multitude of such cases. What does he mean by that? Based on his discussion, what he's saying is most of the time you would assume that somebody had spare parts around and that they're not stopping work on their entire mill just because they send off this one part. And those are some of the hypotheticals that he presents. Nor were the special circumstances made known. So Hadley did not, it seems, impress upon the carrier sufficiently that you need to get this to the repair shop on time because I'm stopping work at my mill waiting for it. Now, as the problem that follows the case in your textbook points out, it seems, if you at least believe the law reporter's summary at the front of the case, that the carrier was on some sort of notice. And so a lot of the debates that scholars have had about Hadley v. Baxendale, and just generally about the notion of foreseeability, is how do special circumstances become known and communicated? Does it have to be as explicit as laying out the express harm? Right? If you do not get this to the carrier, if you carrier do not get this to the repair shop on time, then my work will be stopped at the mill and I will lose, 5 pounds a day in profits. Right? Or is something less than that sufficient? Okay. The part of the debate is, what did Baxendale really know? What had been communicated to Baxendale? The book also discusses, and I'll touch on briefly here, this notion that a line of cases had developed that had come to be known as tacit agreement approaches. And the tacit agreement approach is essentially that the plaintiff really made known to the defendant in an explicit manner what the harm would be that would arise from defendant's failure to perform. And that it had been so explicit that the defendant, even if they didn't say expressly, yes, I agree to take on the risk, it could be said that the defendant knew and understood and tacitly, silently agreed to take that risk on. If the defendant breached, it understood and knew and agreed that it would owe these additional damages. That's discussed on page 877. The modern approach, right, and the UCC very much takes this modern approach, says explicitly in the comments to the UCC that the tacit agreement test for recovery of consequential damages is rejected. But the modern approach is that if the defendant knows or has reason to know of these special circumstances, then usually that is enough to find them liable for consequences that flow from their breach. And the modern case that we're going to look at and talk about in class, McNaughton v. Charleston Charter School, is applying the consequential damages foreseeability standards. right, in a modern setting. The other topic that we're going to talk about in class is this notion of mitigation, that a party, the plaintiff, and who's seeking damages, does need to take reasonable efforts to mitigate the amount of damages that they're facing. And your book includes some discussion on page 885 of the Rockingham County versus Luton Bridge Company case. But I want to flesh out that discussion a little bit more for you to help illustrate this case. And I'll also post the full version of this case. Those of you who are politics junkies may find the political maneuvering that's happening in the case kind of entertaining. So the book sketches out the basic background of this, that there were two highways that were going to be built up to a river. A company had been hired to build a bridge across the river connecting the two highways. There was great debate amongst the county commissioners about whether or not they wanted to fund the building of these highways and the bridge. The group of commissioners that had voted to build the highways and bridge was ousted, and a new group of commissioners came in and was appointed. The new commissioners signaled through a series of resolutions that they weren't going forward with the highway project, they weren't going forward with the bridge. The new county board commissioners sent a number of notices to the bridge company that the county no longer considered the contract valid, and even if it were valid, they did not want the bridge and they were not going to pay for the bridge. And the bridge company, partially it's alleged through reassurances from one of the ousted commissioners who, while they had ceased to go to meetings, was still technically within their elected time period as a county commissioner, it said, no, go ahead, continue constructing the bridge. So what ends up happening is they build the whole bridge. They expect to be paid for all of the money that they expended building the bridge, plus their expected profits for the bridge. And so now I'm reading from the case. The county, ultimately, admits the execution and breach of contract, but contends that the notice of cancellation was given to the bridge company before the erection of the bridge was commenced, and that it is liable only for the damages which the company would have sustained if it had abandoned construction at that time. Okay. So their argument is, we, the county, gave you lots of notice that we were not going to pay for this. We gave you essentially notice of repudiation, and you kept going, thus increasing your damages. We shouldn't have to pay for those increased damages. And the case states that at the time of the passage of the first resolution by the county commissioners, very little work toward the construction of the bridge had been done, it being estimated that the total cost of labor done and material on the ground was about $1,900. But notwithstanding the repudiation of the contract by the county, the bridge company continued with the work of construction. Right. So, did the county breach the contract? Yes. This was a repudiation. Repudiation is a breach. So the county is liable for breaching the contract. The debate is, how much are they liable for? Complaint was filed, setting forth the execution of the contract and the doing of work by plaintiff thereunder, and alleging that for work done up until November 3rd, 1924, the county was indebted in the sum of $18,301.07. So at the time that the county had sent the bridge company notice, we don't want this bridge, we're not going to pay for this bridge. Bridge company had spent about $1,900. Ultimately, they spend around $18,000. That's what they're asking for, right, for the bridge. Now, even though the county is in breach, the court reasons that they don't have to pay as much as the defendant is asking for. And here's the discussion. It is true that the county had no right to rescind the contract, and the notice given to the plaintiff amounted to a breach on its part. But after plaintiff had received notice of the breach, it was its duty to do nothing to increase the damages flowing therefrom. In the case at bar, the county decided not to build the road of which the bridge was to be a part, and did not build it. The bridge, built in the midst of a forest, is of no value to the county because of this change of circumstances. When therefore the county gave notice to the plaintiff that it would not proceed with the project, plaintiff should have desisted from further work. It had no right thus to pile up damages by proceeding with the erection of a useless bridge. Right. The bridge company was on notice, right, that this bridge was not needed, was not wanted. The county stopped building the road that was going out to the bridge site. The court, in its decision, quotes extensively from the Williston Treatise, Williston of our rich man, poor man hypothetical, and others that we've come across over the course of this class. And the idea, as Williston explains it, is if a man engages to have work done and afterwards repudiates his contract before the work has been begun or when it's been only partially done, it is inflicting damage on the defendant without benefit to the plaintiff to allow the later to assist on proceeding with the contract. Right? So Williston's saying it's hurting the plaintiff too in some ways to keep working on something when they've been told they won't be paid for it. And it's certainly increasing the amount of damages that the defendant's going to have to pay. Why? The work may be useless to the defendant, and yet he would be forced to pay the full contract price. On the other hand, the plaintiff is interested only in the profit he would have made out of the contract. If he receives this, it is equally advantageous for him to use his time otherwise. Right? We know from our discussion of anticipatory repudiation that if the party repudiates, you can stop right there and sue them for breach of contract. You can get your expectation damages. You can get the profits that you expected to make on the deal, and you, the plaintiff, don't have to continue working. Right? That's the big concern here, right? That the plaintiff continued to build a useless bridge in the middle of a forest, right, when it could have just stopped working and sued the county immediately. Right? So the court says the measure of plaintiff's damage upon its appearing that notice was duly given not to build the bridge is an amount sufficient to compensate plaintiff for labor and materials expended and expense incurred in the part performance of the contract prior to its repudiation, plus the profit which would have been realized if it had been carried out in accordance with its terms. I'm going to make up some hypothetical numbers just to perhaps shed some light on how this would work, what the differences in damages might be. Right, so we know from the actual case that about $1,900 had actually been spent up to the notice from the county, we don't want the bridge anymore. And we know that the total cost ultimately requested is about $18,000. So that's a 10 times difference, 10 times greater amount. Let's assume that $18,000 was about what the contract was for. And let's assume the cost of building was $10,000 for the bridge company. So they expected to make about $8,000 in profits on the bridge. So if we take just on its face what the court says, which is it should get the amount for labor and materials up to the notice of repudiation, plus the profit it had realized if it carried out in accordance with its terms, we're looking at about $10,000 in damages, right, as opposed to $18,000 in damages. So it is a significant difference when what the non-breaching party is getting is just its profits, right? Plus, here they say costs expended. I think you'd have an argument to make that if it was a cost that they anticipated going into the construction, that you really shouldn't have to pay for those, but I'm just giving you what the court actually articulates. Right? But it's a big difference. Bottom line, you cannot pile on the damages. If you're on notice that the other side is repudiating, doesn't intend to perform, doesn't intend to pay, right, then that is the point where you should stop your performance. And if they have indeed repudiated, you can stop and sue them right there for damages. All right, we'll talk about the Dossier case in the context of mitigation, as well as some of the problems in class tomorrow. See you then.